Hi guys, it's Kathy. I hope you're doing well. I hope you had a good night last night. I have two cats, both named Keo. They're brothers. It's a long story why they're both named Keo. They're talking to each other right now in a not friendly way. They're okay though. No, I'm not sparkly. That's what's cool. This shirt has a lot of green in it. So the background, the green screen, it takes it all away. Green stuff. Like I can't. Lipstick. My lipstick is green. Rubik's Cube. Oh, wait, look. This side's yellow. This side's green. It's pretty cool. I'm going to start wearing more lipstick. Green lipstick. It's, okay, it is green lipstick. I don't know if I can actually show it. I don't think I can. But it turns pink, whatever. It's magic. It's magic lipstick. So, yeah, I like it. So I hope you guys had a good night last night. Sorry, I went out after work with a friend. Stayed out for a while. Not last night, the night before. At some point in the past, I was supposed to stream and I didn't because I went out. Had a good time. And you can't stream at 4:30 after you've gone out and had a good time, or you didn't really have a good time. I had a good time. So it's the weekend. We made it to Sunday. I start work in a couple hours. Then I'm on today's my Friday, so I can't wait. And you were complaining about math. Why? I can do it in about a minute and 42 seconds, but I can't do it in 3 seconds. I can't do it like one-handed like they do. Like, no, it's a puzzle. I play with it as a puzzle. So, let's see. 2 judges today. I think one of them is new. All right, let's start with the one I think is new. Let's start here.
The 172. Ms. Schaffner, who do you have with you?
I have husband Nicholas Koontz, sorry.
And Mr. Rule, who do you have with you?
I have wife Hillary Koontz, Your Honor.
And we are here for a hearing on provisional issues.
So they're going through a divorce, and the wife called this hearing as like an emergency. So it's like an extra hearing outside of the divorce case that's ongoing.
Counsel, have you guys met and have you been able to work out any issues?
Your Honor, previously there was a preliminary four-way conference that occurred. Issues were not resolved. More recently, there have been some developments that prompted the more recent filings. So we haven't, since the more recent filings, we have not had, I know that there has been some correspondence and perhaps some emails or phone calls, but no in-person meetings since the most recent filings.
And are you pinch hitting for Ms. Chekhovich?
I am. I did have enough notice, Your Honor, for some significant opportunity to review the file and get up to speed today. There was a family emergency, but I got a text at 6 a.m. So.
Okay. And historically, years and years ago, when I took over this court, the complaint from Judge King's calendar was you can't get a provisional hearing within 6 months, and by then the issues are resolved. So we started setting summary provisional issues for 3:45 on Mondays, 3:45, because if we set them after 4, we can't get you in the door because security is gone. So that's why we set this at 3:45 today. So in a summary fashion, let me ask this, I know we have evidentiary set in a month from now.
Correct.
Is that for provisional issues or is that for other issues?
I believe that was for provisional issues. That was my understanding. Ms. Jacobucci filed this as an emergency,
Correct.
and just for
Okay, before we get into the emergency, I can't wait because I just found out it's finally up. So I want to show you something quick. I just found out right this second that it's finally up. Redbubble. Redbubble has merchandise. So there's 5 different designs right now. So it's my original Court Vibes logo, but Rebecca fixed it all up real pretty and added the circle and the sword and the wings. There's not just 5 things. So this site is a little confusing. So you go to my site and then you have 5 designs to choose from. Proud Viber, just a Court Vibes logo, Comfort Court Stay for Giggles, Stuck Like Chuck, and Spanked with Jail Time. Those are the first 5 that are up there right now. And to see it, like, you just go shop all products for whichever design that you want. I think all the designs have all the products. So, okay. And not all the products look pretty with the design on it. Like this. This is the bucket hat. You can't see it. And the bath mat is ridiculous. Hold on. Pet bandana. You can't see it. This is a pet blanket and it's so tiny. But the shirts are fine. I mean, I think the shirts are what are important. They're fine. I didn't see a beer koozie. There's zipped hoodies. There's a t-shirt dress. Don't buy that. That looks stupid. I like that though. The little, little mini skirt. I don't like the bath mat. It drives me crazy. And look at that. That's horrible. Tapestry. You can put a huge tapestry on your wall where the tiny little bitty part in the middle is that. We're getting closer to the one that there's a coffee mug. Look at that. Look at that. It's horrible. How can you ruin a coffee mug? That's probably what I would want to order, and I can't because that's just bad. And it's $14. Screw you. I'm paying $14 for that. I want to pay 50 cents for that. The socks are awful. Look at this jigsaw puzzle. And I didn't even see the stupid bath mat, which is stupid. Maybe I took it down because it annoyed. Oh, there it is. I don't like it. Look, it's so tiny in the middle of the bath mat. Anyway, check it out before you order anything. I mean, the t-shirts look great. The leggings don't. I hope they can show you the back where they put the design. There it is. Who the hell is gonna walk around wearing something like that? Who? Yeah, I'm gonna take my $40 and I'm gonna buy that. You ordering that mini skirt for Sarah, Fozzie? So anyway, there's a sticker for $1.50. That's what I have. I'm gonna go back here, and I think this is the correct link. Okay, fine. I guess I have to set this up on my YouTube page, which I will. eventually. But okay. Yeah, I don't have any control over the design. I don't have no control. But at least there's shirts right now. A nice big quilt with a tiny little cord fibers somewhere down near the feet. Oh man. Anyway, you can get a Stuck Like Chuck t-shirt. So now we're back into this emergency hearing this wife is calling for.
Just so the record is clear, I do object to a summary argument because Ms. Jacobucci is asking for my client to pay fees, including attorney's fees and certain other fees. And so my client would like to bring witnesses in to be heard on those expenses that she is requesting. He would like to provide testimony.
Happy to accommodate. Mr. Rule, I thought the emergency was there was going to be some kind of either eviction or a loss of a marital property.
Utility shut off with potential risk associated. And Your Honor, just to address Ms. Schaffner's comments, there will be no arguments for attorney's fees or anything like that today. That'll all wait for an evidentiary hearing. We had a limited issues to address on what we believe is an emergency basis relating to a disconnect notice that was scheduled to shut off power on the 23rd of October, along with two other issues related to essentially the suspension of payments toward things that have been customarily paid for. I don't know if you want me to start summarizing right now, but we have essentially.
Well, to me, a provisional hearing is who's paying the bills between now and the finalization of the divorce so that we can preserve marital assets and kind of preserve any children in kind of a safe environment that they've been in. Here, when I see emergency, I always cringe because to me, emergencies are fire, police, and EMT, not me. But when I see emergencies where somebody could possibly be displaced or something has happened, and I can have a summary argument on that issue, I'm happy to do that. Ms. Schaffner is objecting to the summary of that. So I am left with, I can, sua sponte, I think, enter an order for payment of monthly fees without any evidence. And if I'm not going to hear any summary argument, I'll just do that. I think pursuant to Article 73, I'm allowed to make certain things without having a hearing. And then I can make some temporary things until we can get back here till November.
I was just making the record clear for purposes of appeal, but my client would like to be heard, Your Honor, especially if he's going to be ordered to pay expenses.
And I understand that, but if you object to the summary fashion on just the expenses, I'm not allowed to proceed that way, and that's not going to be upheld. I guess you could appeal, and a year from now we could come back on that issue. But in the meantime, there's a question of disconnection of services and some other things, and I can enter a quick temporary order that we can then hear evidence on in November. So I guess my concern is, NIPSCO and water and power being shut off when wintertime is on its doorstep here. So, and I don't know where you guys are at with that particular issue. I was not going to hear anything on fees today, on attorney fees or anything else. My concern was possible displacement. So if you're okay with hearing summary on just the NIPSCO bill and what other bills are crucial that could displace somebody from their home.
So Your Honor, as far as crucial that can't be addressed after the fact, just the summary position is there has been communication and a threat by the husband to stop paying for everything, including utilities, car payments. And we would just ask that until the
Is the car in danger of being repossessed?
I don't believe so, Your Honor.
Okay.
No,
So to me, that's not an emergency.
No, he's currently paying everything except for the NIPSCO bill.
Okay. And what is everything?
The mortgage, both car payments, the car insurance, the water, the trash, the credit card payments, the medical insurance.
Well, then, Mr. Rule, that is just the NIPSCO bill. Then if he's paying everything else, what's the emergency?
So, Your Honor, and depending on how much we want to talk about today about so my client, for 17 years has not worked a full-time job. Since the dissolution has been filed, she now does work part-time. Her expenses exceed her income at this point. The income ratio is about 89% to 11% based on the numbers that we've run. So she flat out was not able to pay the NIPSCO bill. She has had to borrow money, $1,000 from her family, which she in fact did, to avoid shutoff. She paid on Friday after we filed the motion. But now we're at the point where we're going to seek reimbursement for that because she had to borrow that money. She went to the trustee's office. She went to another government agency trying to get money. She literally just did not have the money to pay it.
And I'm assuming the mortgage is way more than the NIPSCO bill.
Oh, yes, absolutely. The mortgage is almost $1,300,
Okay.
$1,400, I'm sorry.
And so father is going to continue to pay those types of things. He's just not paying the NIPSCO.
Correct.
So those types of things are controlled numbers where the NIPSCO can vary up and down.
Correct. And she lives in the home with her son from a previous relationship. Correct.
Okay.
NIPSCO's not budget. Saying everything.
Is it budget plan NIPSCO or is it a?
She believes so, Your Honor.
Okay. Mr. Rule, I know we're here on a summary basis, but I'm hearing probably if you add the car payments, the insurance, the mortgage, are we going close to 80% or 89%?
Your Honor, so we calculated the numbers and ultimately his income based on prior tax years and up-to-date information as best we have, the marital income, he makes 89%, she makes 11%. Even paying, if we fast forwarded everything that we would request, we calculate that his disposable income monthly will still exceed $4,000. Her disposable income goes to either zero or minimal, just paying food, gas, expenses for her child, phone bills, and things like that. So we're literally at the point where she can't afford all the bills plus the NIPSCO bill that he's been customarily paying, but just simply stopped a couple of months ago.
But as we get through this divorce, as we always do, this is just provisional temporary things. At some point, those things are going to stop getting paid.
Understood, Your Honor. Understood. She has, as far as arguments as to whether she's changed, she has now part-time employment, but with no work history for 17 years, her ability to find full-time employment with a child still in the home who doesn't drive yet, those are the circumstances we would talk about at the full evidentiary hearing. But that's the nature of the request. It's just right now she just didn't have the money to pay it and it was about to be shut off.
Well, here's what I'm going to do. I think payment of the mortgage, car payments, and other bills are reasonable. When I see these types of things, and I've had this happen in the past, it looks like somebody's being completely cut off and they're going to lose their home and lose their electricity right before winter, which is problematic if the income is that much of a disparity as far as income. I'm hearing from Ms. Schaffner that her client's going to continue to pay all of these other things. So I am not going to take any action. We can have the full evidentiary hearing in November and sort out attorney fees and other fees and all of those types of things there. This is much different than I was expecting. I was expecting to hear that somebody was being cut off and they were about to lose their home. So based on what I'm seeing and hearing this in a summary fashion, I'm not going to grant any emergency relief, and we will have this full evidentiary hearing on November 20th, 2024 at 1 p.m. I think we're set for 2 hours. Counsel, is that going to be enough to be able to hear all of that, then, at least for these temporary issues?
I'm not sure that Mr. Rule would be able to answer that question in all fairness.
Well, how about, do you think, is that enough, or do we need to be?
Probably not. Probably not.
That may be a question that my staff will be contacting you and Ms. Jacobucci to try to make sure that we get this in enough time to be heard. So thank you for appearing.
Thank you.
Sorry, Mr. Rule, you had to do this at a last minute notice, but like again, when I see those pleadings, it looks to the court like somebody's going to be homeless, and that's what I wanted to make sure was not happening. So thank you for appearing.
Thank you.
Ridiculous. Woman, you're ridiculous. Get a job. You have a child, not his child. You have a child. He's paying for everything else. And you called an emergency hearing because he didn't pay the electric. Get a job. Get 2 part-time jobs if you can't find a full-time job. I've always had 2 jobs. Oh. Ah. Yeah. I do remember going to my boss one day. I the 3 kids at home. I was lying. I'm like, you gotta give me some mac and cheese, please. Just give me some mac and cheese so I can make it through the night. And she did. She got me some mac and cheese. But I had to. I had to get food for that night. That's all I was thinking about. Food for that night. I was only making, I don't know, minimum wage, whatever. I'm like, please, please give me some mac and cheese. It's hard at first. Divorces are hard. Divorces are freaking expensive. No matter how much money you make, you get a divorce and your money, whatever you have, no matter how much you make, is gone. You just know that it's gone on both sides. But yeah, divorces are rough. However, they wouldn't be so financially rough if she would get a job. I mean, come on. You have a child. You have to work. You have to get stuff for your child. You have to. Your soon to be ex husband is not in charge of raising your other child, paying for his electric. All right. This next woman is my soulmate. Oh, I love it. I love it. Here we go.
Client can hear me.
Uh-oh.
Oh, okay. I guess Mr. Miller can hear me now. So we have all parties here. Nicole, we can go on the record. All right, we're on the record in 49D22, 2012 JP 043937 in the matter of the paternity of Jace D. Miller. We do have all parties present. We have the petitioner Justin Miller present with counsel, Mr. Cassis. We do have the respondent, Ms. Waldrop, representing herself. This matter comes on for a rule to show cause on petitioner's motion filed August 21, 2024. Are the parties ready to proceed?
Yes, I am, Your Honor.
Okay, Ms. Waldrop?
Yes.
Okay. This is your motion, Mr. Cassis. You may present any evidence or witnesses you may have. This is set for 30 minutes today, and I do have other hearings.
Judge, no problem. I'll be fast. I'm going to call Justin Miller as my first witness.
Okay, Mr. Miller, I'm going to swear you in at this time. Can you please raise your right hand for me? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalties for perjury?
Yes.
Thank you very much. You can put your hand down. Your witness, Mr. Cassis.
Thank you, Your Honor. Justin, please say your name for the record.
Justin Miller.
Justin, you have a child in common with Amanda Waldrop, is that correct?
Correct.
Name and age, please.
Jace Douglas Miller. He's 4 years old.
Justin, are you familiar with our agreed modification dated January 19, 2024 that we entered into earlier this year?
Yes.
Is it your understanding that respondent, Ms. Waldrop, was to submit to fingernail drug screen within 48 hours once a year starting June 1st, 2024 through the year 2026?
Yes.
And did that occur on June 1st of 2024? Did that occur?
I did not.
Okay. Did you have any communications with Ms. Waldrop about the drug test on or about June 1st?
Yes.
What was the nature of that conversation?
I believe June 1st was a Tuesday, maybe.
Mm-hmm.
She asked me if she could take the test on Wednesday because that was the day that she doesn't have Jace. We both agreed that's fine. She didn't need to take him to do something like that. And then she would get the results back to me.
So as of that conversation, you expected that she was going to go the next day, which would have been the 2nd, and she was going to take the test and you were going to get the results. That was your expectation.
Correct.
And this is a fingernail test, correct?
Correct.
And what is the lab, if you know what lab was this to be happening at?
Oh, I don't remember the labs.
Any lab test now? Does that sound familiar?
Yeah.
Okay. Was there any payment arrangements for the testing that you and Amanda had? Did someone put a card on file with the lab?
According to our agreement, we were to split the charges of the test, the cost of the test. She messaged me and said she took the test and I Zelled her half of the money. I think my half came out to roughly $75.
Okay, so you paid your share of that then? Okay. When did you pay your share, if you recall?
That Friday, the following day.
That same week?
Yeah, after she told me she took it.
Okay. And did you receive in the days and weeks, I guess, prior to filing our petition on August 21st, did you ever receive any results?
No,
Did you have any follow-up communications with Ms. Waldrop about the results?
I asked her, I messaged her a month later and asked if she got the results back. I messaged her a month after that and asked her if she got the results back, and a few weeks after that.
Well, did she answer you?
Yeah, the first time she told me she accidentally deleted the results and they would send them to her. And I said, okay, that's fine. Just get it to me. I want to say the second time she told me she couldn't get a hold of them. She didn't know what was taking so long. One of the final communications we had said she wasn't giving me the results.
When was that?
Our last communication was 8/2/24.
And then we filed the petition on 8/21 of 24, correct?
Correct.
All right. So, Justin, is it fair to say this wasn't a situation where you ran into the court the day after June 1st and filed the contempt? You attempted good faith efforts to resolve this without the need for court involvement, correct?
Correct.
And ultimately, Amanda told you that she wasn't going to give you the results, correct?
Correct.
And in your mind, you believe that that would violate the terms and conditions of the January 19th, 2024 order, correct?
Correct.
And again, we have that order in place, I assume, because you've had concerns about drug usage in the past.
Correct.
Correct?
Correct.
That order be complied with so that we can make sure that there's no drug usage going on.
Yes.
Now, we filed the petition, and now it is October 25th. So we're about approximately 2 months after we filed the petition. Between the time of filing and today's date, have you subsequently received results?
Yes.
When did you receive results?
I want to say it was a week or so after our last hearing, our first hearing. Our first hearing
Okay.
was scheduled.
So you're referring to the hearing that we had scheduled.
The 4th.
I want to give you the date, Justin. I want to make sure I got it right.
October 4th.
October 4th. Yeah, thank you. October 4th, correct?
Correct.
It was after October 4th that you received the results.
Correct.
And how did you get the results? Did Amanda send them to you, or did you get them from the lab? How did you get them?
She texted them to me.
And were the results negative?
They were negative.
And did it have a date on the test when the test was actually taken?
Yeah, it was June 3rd or whenever we agreed for her to go take it.
Okay, so she in fact took the test as she was required to do when she was supposed to, roughly when she was supposed to take it, correct?
Correct.
She just wouldn't give you the results.
Correct.
Now, that order that we have contemplates annual testing up until through 2026, correct?
Correct.
Are you concerned that we're going to run into the same problem for future tests that we ran into this time?
I'm hoping we do not have the same problem, but yeah, it's a concern.
And given that the results are negative, I'm assuming that gives you some peace of mind, correct?
Absolutely.
But do you feel you should have had to have filed the petition on August 21st, incurred attorney's fees to get to the point to get the results that you should have been given months ago?
No, I feel like this could have been avoided.
Okay. And you incur expense with me to file and then, of course, to come to court, correct?
Correct.
All right. Are you asking that Ms. Walter be found in contempt for violating the terms and conditions of the January 19th order, specifically as it relates to providing you with results from the drug screens?
Correct.
Are you asking that she be ordered to reimburse you attorney's fees for bringing this action?
Correct.
Are you asking that you be reimbursed $1,000 in attorney fees?
Correct.
When Amanda told you in August 2nd that she wasn't going to give you the results, did she tell you why?
It was vague.
So you weren't clear as
It
to why.
wasn't vague.
Do what? I'm sorry, I was breaking up.
Justin, can you hear me?
Yes, I can hear you now.
Uh-oh.
Mr. Cassis, your next question, please.
I think it was me that froze. Justin, can you hear me?
Yeah, I can.
Okay, I couldn't hear your last answer, Justin. Was it unclear as to why?
She told me she wasn't giving me the drug test results because it was degrading.
Okay. All right. Your Honor, that's all I have on the issue of the contempt.
Okay, thank you. Ms. Waldrop, do you have any questions for Mr. Miller based on the answers that he gave?
The only thing that I just want to say is that June 1st was actually on a Saturday, so I scheduled it for that Wednesday. Looking back through my text, I did not, after scheduling it on the Wednesday, did I say I would give you the results after? And can you find the text, Justin, of where I said that I just wasn't giving them to you?
I mean, I don't have it in front of me right now.
Okay. Yeah, I mean, I took the test when I was supposed to. I apologize that I didn't get it to him immediately, but it was kind of one of those things of it didn't specify that I had a time limit of when I had to deliver those. So that's all.
Thank you. Mr. Cassis, any redirect?
No, Your Honor.
Okay. Any other witnesses or evidence that you wish to present?
Yes, I'd like to call Mother if I could.
Okay, Ms. Waldrop, I'm going to swear you in. Can you please raise your right hand for me?
Yes.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalties for perjury?
I do.
Thank you very much. You can put your hand down. You're a witness, Mr. Cassis.
Thank you, Your Honor. For the record,
You're breaking up, Mr. Cassis. Can you please restate the question?
Judge, I'm going to try to get to a better location because I got bad signal. I just need a second to move to a different spot.
Okay.
She's about to tell him the real reason why she didn't give the test results. She took the test on the correct day. She got the results back within 48 hours. But she didn't give it to him. And it's hilarious.
Okay. Judge, can you hear me now?
Much better.
Okay, wonderful. Ma'am, can you please state your name for the record?
Amanda Waldrop.
Ma'am, are you familiar with the order dated January 19th, 2024?
Yes.
And that was an agreed entry that you signed, correct?
Yes.
And you had counsel at the time that you executed that document, is that correct?
I did.
And did you read that document before you signed it?
Yes.
Did you understand that document when you signed it?
I did.
And is it accurate that pursuant to that order, you were to take a drug test on or about June 1st?
Yes.
And did you in fact take a drug test on or around June 1st?
I did.
And was that lab any lab test now?
No, it was not.
Which lab was it?
It was the, let me find it was the affordable drug screen in education.
Okay, very good. And did you indicate to Justin how much the cost was?
Yes.
Did he sell you 50% of the cost back to you?
He did.
When did you receive the results?
I received them on, I'll have to find I can't find the actual results, but it was a few days later. I think it was like the 8th
All right.
or the
Were
12th,
there
that week, the 8th of the 12th.
in June, you got the results?
Yeah,
Okay. Did you have some text communication with Justin about the results?
I did.
And did you turn over the results in June when you
I did.
received them?
No.
When did you turn over the results?
I believe he was correct on about the date, but I'm trying to go back to see when that was. But I believe it was just within the few days of, I think it was that Monday or Tuesday after the 4th.
Of October?
Yes.
Okay. And did you send a message to Justin in August of this year, early August, whereby you indicated that you were not going to be sending him the results?
I am not 100% sure I remember that text. I'm trying to go back to see, but I don't recall.
Is there a reason why you wouldn't have given the results upon receiving them?
It was more of me asking him a question that he wouldn't answer. So I hadn't turned him over and hoping he would answer a question that I'd asked.
What was your question?
It was just asking if he was dating somebody else.
Okay.
It wasn't really worth all this at all. No.
All right. Do you feel like you have a good understanding of our order and what it says?
I do, but it was the only thing was that it didn't have a specific time frame of when I needed to turn those over or that I had to turn them over to him. It was that I had to take a drug test and I followed that.
Okay. So you know that this order contemplates some additional testing to happen in the future. You're aware of that?
I'm aware.
Hold on, guys. Wait till you hear what the judge says.
And I anticipate that you're going to comply with that when the time comes.
Yes.
Are you going to require pleadings to be filed in order to ensure the results are turned over to Justin?
No.
Are you going to give the results once you receive them?
Yeah.
Okay. That's all I have on this, Judge.
Okay, thank you. Ms. Waldrop, do you have anything further you'd like to state based on the answers you gave?
I just want to state that I have complied with everything that we have agreed to. I've maintained sobriety, went and taken the test. I actually signed the agreement that he had proposed to me, in which I was told not to sign because I wanted him to feel comfortable with me and know that I had, you know what I mean, continued sobriety. I understand his concerns and I understand where he's coming from, but in the same sense, it just felt like it was a control thing. You know, I complied with my order. It was just me being childish. I really don't have much more to give an excuse, but I just don't feel like it's contempt being the fact that I did give over the results, but there wasn't a window of when it said I had to, or that I had to.
Okay, thank you. Mr. Cassis, do you have any further questions on that?
No, Your Honor.
Okay.
So, so is she in contempt? Is she in contempt of court for not complying with handing over her drug test? It was very petty. It was very, very, very petty.
All right, and then Mr. Cassis, you don't have any other
I just
further
have
questions?
I just have
Okay.
argument, no other witnesses.
And then Ms. Waldrop, do you have any other witnesses or evidence that you wish to present?
No, sir.
Okay, so I'll give a brief closing argument. So Mr. Cassis, please.
Thank you, Your Honor. Your Honor, I think that this could have been avoided, honestly, with just
Maybe.
a little bit of reasonableness. The test was taken when it was supposed to be taken.
Yes, it
The results
was.
were negative,
Yes, they
which
were.
is good, which is great, in fact. But those results were never communicated to my office or to Justin. And it sounds like it wasn't because of something that had nothing to do with what we're talking about. Quite frankly, it was just out of immaturity, is what it sounds like. And that resulted in us waiting for a
Patty
couple months.
Queen.
And Justin
Yes.
didn't come to the court and file a contempt the next day, made reasonable efforts to try to resolve this without court intervention. And only after we filed the contempt and only after we had a session with Your Honor on October 4th did we actually get the results. And it shouldn't come to that. It shouldn't have been that hard to get the results. And so we are asking the court to find mother in contempt and to award $1,000 in reimbursement of attorney's fees, in the hopes that that will serve as an admonishment to mother to not create scenarios like this again in the future when it comes to complying with this court's order. That is our request at this time, Your Honor. Thank you.
Okay, thank you. Ms. Waldrop, do you wish to give a closing argument at this time?
Yes. I just want to say, yes, it was immature. This could have been avoided. Absolutely. It's embarrassing that we're here, honestly, wasting all of our time. I do feel like when he had reached out concerning the results, they were very vague of, did you get the results? Okay, I'm not fighting you, etc. Had he told me that he was going to take that farther and file a contempt, I would have offered those over. I didn't really foresee him going this route. I guess that was a miss on my part. I feel like had that been communicated, I would have offered that up, being the fact that nobody wants to be here. And I don't feel like I should have to pay the attorney fees, only because nothing was set in stone on dates, who it needed to go to, if it needed to go to anyone. So if that was necessary, I feel like that should have been written in their offer that I agreed to. And I mean, going on further, I'm willing to give him those results, but I did comply with my order. And that's all.
Thank you. So parties, thank you all for attending. I do actually agree with both parties that this hearing didn't need to happen, nor did we need to get to this point. So I do agree with the parties on that. But my job here is to apply the laws to the facts. So I've looked at the agreed modification that was filed on January 19th of 2024. I do agree with Ms. Waldrop that it does not specify timeframes. So she did adhere to what the agreed modification was. So I declined to find Ms. Waldrop in contempt. However, I am going to add some additional guardrails to make sure that we don't come back here again. Because I think there are some things that are vague that need to be clarified. So, because there are further tests that have to go on for the future, I am going to add 2 additional orders to clarify some things that Ms. Waldrop, you're still supposed to comply with paragraphs 3 and 4 of the order and paragraph 5 if that hasn't already been done. So that's clear. What isn't clear is when you should be turning over proof of that, and the court's going to order that now. So you're to turn that over to both Mr. Miller and his counsel within 48 hours of receipt of that test. Court is also going to add another clarification that says paragraph 6 is if mother fails any of the screens. I'm going to treat that how I would treat it at, say, a problem-solving court, that a missed test is also considered a positive test in that matter. So I'm going to clarify that. So those will be 2 additional conditions that, just to be clear, Ms. Waldrop, you're to provide proof of that test within 48 hours of receipt. That does not, getting to October is when this was taken in June is way too far out, and that if you do miss that test within that window, paragraph 3 and 4, it is considered a positive test in the court's eyes. Mr. Cassis, do you need any clarification on the court's order?
No, Your Honor, I don't. Will the court do a hearing journal entry or?
Yes, that was my plan if the parties are consenting to that.
Yes, I would consent to that, Your Honor.
Okay, Ms. Waldrop, do you have any questions about the court's order? And are you fine with a hearing journal entry, which means that this is still the court's order, but it's not going to be a typed order. It's going to be an entry from today's date of the court's
Okay,
order.
yeah, I agree, but if we could put in there, within the 48 hours of the, the date that it needs to be taken unless, communicated between me and Justin, like had it been on a Saturday, excuse me, with it being on a Saturday, I wasn't able to take it till Wednesday or till I not have Jace, if that makes sense.
I understand what you're saying. So I'll grant that request. So paragraphs 3 through 5, I'll add that unless agreed upon by the parties, but that still applies unless the parties do agree similar to what occurred this year. Okay.
Thank you.
Anything else?
No,
No,
Judge.
So she was super petty because he wouldn't tell her he was dating someone else, and she won. Oh, I bet he's mad right now. I would be so mad, but I love it when petty wins sometimes. They're fine. They're gonna get a divorce. Everything will be fine. It was just a sidebar real quick. I mean, her tests were clean. She's fine. Everything's fine. Okay, it's time to go way back in time to Fleischer Friday. And I'm pretty sure I missed Fleischer Friday. So we're gonna watch this together. I don't know. It was just like yesterday. That father was not yesterday, the day before, 2 days ago, 4 days ago. I don't know. That father was a monster. He should have gotten charged, and he didn't. She should have gotten contempt of charge, and she just didn't. It's just, I mean, he has to follow the law. And if it wasn't written in the order how much time she had, she didn't break the order. She did exactly what she was supposed to do. And yeah, he's out that money. But he could have waited until the next hearing. But and then the other judge, at least the first judge was right. The man did not have to pay the power bill. The man she needs to get a job. Oh man, I wish we had drunk judges. That would be so cool. That would be so cool. Or could you imagine if the judge was high and the people would come in and he would just start like giggling, giggling at everything they said. Oh, oh my god, that would be hilarious. They got a bag of Doritos. Bill, Bill, you're killing my buzz. Okay, that would be very, very funny. Now let's go with bull cut number 7.
Consented to breath. The breath results were 0.125, 0.120.
Okay.
And this defendant is driver's license eligible, Judge.
Any prior DWIs?
No, Judge, no criminal history.
Okay. Mr. Bueno, I'm going to find that there's probable cause to go
Oh,
forward
no.
with the case. You have a valid.
Snoop Judge would be fine. He would be perfectly fine. But no, like like Judge Reese. Judge Reese hires a guy. Someone slips him a cookie. And he's on the stand giggling at everybody. Eating, well, maybe Judge Fleischer does like to snack. No, I'm joking. That would be funny though.
Texas driver license.
Oh, no, not currently, no.
Let me run the LCIC to be sure, Judge.
If you do not have a Texas driver license, you're not allowed to drive, and I am making that a condition of your bond. You must have liability insurance as well. Unless you have both, you're not to drive. If I find that you drive, I'm going to put you in jail. You will not get any more PR bonds.
He probably already
Do you
is.
understand?
Yes, sir.
You will be signing an affidavit with me today. This is a promise that you're going to make. I don't care what's going on in your life. You cannot justify getting in a car for any reason.
All right.
Do you understand?
Yes, sir.
He is eligible, Judge. He may not have one now, but it's not suspended.
Okay, get a license, get liability insurance, and then we will let you drive. I'm also ordering you not to consume alcohol or illegal drugs. We're going to randomly test you. If I find that you're consuming alcohol or kind of illegal drugs, I'll put you in jail. No more PR bonds for you.
Yes, sir.
How old are you, sir?
Just turned 21 last month.
What do you do for a living?
I'm a framer in a refinery.
How much money do you make a month?
Right now, 17 an hour.
Who do you live with?
My mother.
You pay rent?
Yes, sir.
How much do you pay rent a month?
350.
Okay. You may be able to hire a lawyer. I want you to start looking around. Okay. If you have any issues, come back and we can talk. But I mean, if you're making 17 an hour, you work full time, right?
Yes, sir.
So you're making what, $4,000 a month then? Give or take, right?
Yeah.
Yeah. I mean, you have to qualify for an appointed lawyer, you have to be at the poverty guideline. And so, I mean, you're doing great, which is a good thing, but I don't think you necessarily qualify. So start talking around with lawyers. You need to do it quick. This is a DWI. There's a lot of timing requirements. So don't wait a month or two because you're only hurting yourself.
Yes, sir.
You understand?
Yes, sir.
Okay, I'm gonna have you sign this affidavit. After that, I'm gonna have you go to Victoria, sign and reset. After that, you'll go to pretrial for your bond conditions, and after that, you'll be free to go. When you come back, please have a lawyer, okay? All right.
But giggling while he says it.
Castro.
Memorio Castro.
Yes, sir.
Mr. Castro, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 18th of 2024, officers were traveling at the 10900 block of Scarsdale Boulevard. When officers observed the defendant's motor vehicle driving on the rim, a traffic stop was conducted. Officers observed the defendant exit the driver's side of the vehicle. The defendant immediately stated he had been drinking and advised he had 5 16-ounce beers and told the officers he was drunk. As if the C's were refused at the time, officers detected odors of slurred speech, glossy red eyes, lack of balance, and moderate odor of alcohol in the breath on the defendant's person. The DIC was read, the defendant refused, and a blood warrant was signed and executed.
Okay. Mr. Castro, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
Yes, I do.
You have liability insurance in your name?
Yeah.
I do see that the driver's license is eligible and there's no criminal history.
Okay, Mr. Castro, you can drive as long as you have liability insurance and you have a valid Texas driver license. I am ordering you not to consume alcohol or illegal drugs, and I will randomly test you. If I find that
Premature lives matter.
you're consuming alcohol or any illegal drugs, I will put you in jail, revoke your bond. You will not get any more PR bonds. Do you understand?
Yes, sir.
How old are you, sir?
31.
What do you do for a living?
Service technician.
Okay, we're going to give you time to hire a lawyer. So I'm going to have you go to Victoria, sign a reset. After that, we'll get you to pretrial services to sign for your bond conditions. And after that, you'll be free to go. If you like your driver's license, find a lawyer quick. Don't wait a month or two because you're only hurting yourself.
Okay.
You understand?
Thank you.
Okay.
Flores. Page 4.
Morning, guys.
Enrique Flores. Mr. Flores, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 19th of 2024, officers were dispatched to a residential home in Harris County, Texas regarding a disturbance. Upon arrival, officers met with the reportee who advised the defendant had just left the location in his vehicle. Moments later, officers observed the defendant arrive back at their original location in his vehicle. Upon contact with the defendant, officers observed signs of intoxication, namely bloodshot eyes and odor of alcohol in the breath from the defendant's person. SFSCs were administered, 6 out of 6 on the horizontal gaze and nystagmus, 5 out of 8 on the walk and turn, and 3 out of 4 on the one-leg stand.
Brayden,
ERCs were
is
read.
that a mess
The
of
defendant
membership?
consented to blood. A blood draw was signed and executed.
Well, so there wasn't a traditional stop here. What happened?
There was a call from a witness regarding a disturbance. They stated, I don't know what that is. I can take a look at the specifics
Okay.
of that for you.
And then,
And they said the defendant just left in his vehicle. They observe him come back. It turns into a DWI when they observe him operating the vehicle and they start talking to him and he's got signs of intoxication.
something illegal in the car, some kind of traffic infraction?
No, Judge, I believe it's just they're investigating the disturbance and it turned into a DWI after they observe him operating the motor vehicle.
What disturbance?
I can take a look, Judge.
Please. Did David Freeze check in?
No, Judge. Judge Wilkinson?
So Judge, it looks like the report initially indicated that there were threats made from the reportee, from the defendant to the reportee, and they believed that he was under the influence of alcohol and had just left in a vehicle. They observe him come back and they observe signs of intoxication. They investigate the threats and it turns into a DWI once they observe him operating.
So are they saying that they called because he was a
Because of the
DWI threat?
Judge. Yeah, both, Judge, threats and possible DWI.
Mr. Flores, I'm going to find that there's probable cause to go forward with your case. It's a prior deadly conduct. I'm trying to look into that and
Yes, Judge,
how
it looks
dangerous
like
of a
he took
person.
Plea of guilty on 16 days county.
We have in 23, a felony assault, a deadly conduct where a knife is exhibited, and now we have this DWI where there's a reportee with potential family violence involved. Same complaining witness?
Different. The felony cases were a dating relationship. This case, it's immediate family, brother or father.
One more question.
Yes, Judge.
In the felony cases, any kind of alcohol or dope is an allegation, is
I can check for you.
parcel
Judge.
of the problem. You know, there are some people, Mr. Stand up.
Yes.
There are some people, when they drink, they become very happy people, like little bunnies jumping in the woods. And then there are those that when they consume alcohol or illegal drugs, they turn into a complete horns and not very nice people. If this is you, don't consume alcohol or illegal drugs. And I'm going to put a monitor on you to make sure that you're not consuming. If I find that you use anything, I'm going to lock you up, deem you a public danger, and make your bond sky high. Do you understand?
Yes, yes.
And Judge, yes, alcohol was a factor in the felony.
Both?
Yes, Judge.
You have a prior felony deadly conduct. You have a prior felony assault. One constant remains in all of those cases. What is that constant? Right. I'm going to put a monitor on your ankle so I know that you're not consuming alcohol. If you have a problem with drugs or alcohol, you better address it, because if you don't, I'm going to do it for you. And I promise you, Mr. Flores, you're not going to like the way that I do it. Do you understand? Do you have a Texas driver license?
Yes.
Can you run this license, please? Do you have liability insurance in your name?
And the vehicles that I have are,
Do you
Yes,
have
yes,
liability
yes, I-
insurance in your name to drive any vehicle that you're using?
see, the vehicles that I have are for my workers. I don't have a vehicle right now. It was, somebody totaled it. So, sorry, I'm trying to make sure.
Do you have car insurance?
Yes,
When in your name?
yes.
You're not allowed to drive any vehicle that doesn't have your name on any kind of insurance on the car that you're driving. If I find that you do, likewise, I'm going to put you in jail.
Okay.
Do you understand?
Yes, I am.
I'm only asking you to comply with the law. I'm not asking you to do quantum mathematics here.
The judge's license is currently eligible.
So I'm going to order
Jazzy can do quantum mathematics.
regarding interlock. And then, but we're going to put a scram on him. I'm going to pay for it for you so that there's no excuse for you. You must charge this battery on a constant and daily basis. If the battery dies, so does your bond. Do
Okay.
you understand?
Yes.
We all hope there is screaming though.
So you saw on this one that we're ordering a scram? Okay, 3 days to get, please, and waive the fee. We're going to reset your case to give you time to hire a lawyer. So I'm first going to have you go to Victoria, sign a reset. After that, you'll get with pretrial for your bond conditions. And after that, you'll be free to go. If you like your license, get on it quick. Don't wait a month or two to get a lawyer because you're only hurting yourself. Please.
Garza. Garza on page 5.
Robert Garza. Mr. Garza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On October 19th of 2024, officers were traveling eastbound on the Sam Houston Tollway when he conducted a traffic stop on the defendant's vehicle after observing it travel at a high rate of speed, 99 miles an hour in a 65-mile-per-hour zone. Upon contact, officers observed the defendant as the driver and sole occupant of the vehicle. Officers observed signs of intoxication, namely slurred speech, odor of alcohol in the breath, and glossy eyes. The defendant admitted he was coming from a party where he had consumed a six-pack of alcohol. As the VSTs were administered, 6 out of 6 on the horizontal gaze nystagmus, 4 out of 8 on the walk and turn, and 1 out of 4 on the one-leg stand. DIC was read, defendant refused. A search warrant was signed and executed for the defendant's blood. And Judge, there's no criminal history here and the license is currently eligible.
Okay. Mr. Garza, I'm going to find that there's probable cause to go forward with your case. Do you have valid liability insurance in your name?
Yes.
Okay. If I find that you drive like this at or above 99 miles an hour, or
Guys, is Victoria getting sick? She's coughing and sneezing over there.
Something like that, I'm going to take away your privilege to drive. Do you understand? We have speed limits for a reason. We have on every day, someone dies in Harris County because of some kind of alcohol-related collision. Not on my watch. If I find that you drive like this again, no more driving. Understand? I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or any kind of dope, you will go to jail. You will not get any more PR bonds. I see that you have a lawyer. Because you have a lawyer, I will waive your appearance, but you must stay in touch with Mr. Runcie, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Don't pick up any new cases. Don't drink and don't drive like a complete. You understand?
Sir.
I'll have you sign a receipt with Victoria, and then we'll have you sitting back and wait for your lawyer to arrive. Please.
Gus? Page 6. This one, Judge, was reinstated in open hours court.
Cameron Gus. Mr. Gus, you're charged with unlawful carrying of a weapon. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. Excuse me, you have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Officers in Harris County, Texas observed the defendant driving at a high rate of speed and attempted to gauge that vehicle's speed. As the officer pulled out to pace the defendant, he heard the defendant accelerate at a high rate of speed. Officers initiated emergency lights and began to pursue the defendant in an attempt to conduct a traffic stop, reaching speeds of up to 130 miles an hour.
130?
Yes, Judge, just to catch up to the defendant. While on the south loop, the defendant turned off all of his lights in an attempt to escape police custody. After approximately 2.9 miles, the defendant pulled over.
I hate you.
And him, along with 2 other passengers, were detained.
That hurts.
While being detained, the defendant stated, quote, "I know what I did," and told officers that a handgun was in the vehicle. Officers found a black handgun on the driver's side seat, unholstered in plain view. Miranda rights were read, and defendant did admit to owning the gun. And this is connected to a felony evading, Judge.
And I see that it was discharged. What happened on that? And tell me, what initially led the cops to him? What was he doing wrong initially?
It looks like they had already observed him driving at a high rate of speed, but it doesn't look like there's a number that they paced him at. I believe that may
That's
have
why.
been the reason. Yes, Judge.
Fine. I mean, or look in the report.
I can check the report. for you,
Please.
Judge. Yes,
Because
Judge.
if they can't, if it's just conclusory, you know, well,
Yeah, but okay. If they didn't have probable cause, he still completely broke the law. Going 130 miles an hour. I mean, I know that's not how fast he was going. That's how fast the cop had to go to catch up. Are you really a DA, Val? Are you an actual district attorney, defender, prosecutor? Or maybe you're like Darren at work. He does workers' comp. He's a workers' comp attorney. He comes in all the time. He makes good money being a workers' comp attorney, which has to be so boring. But the thing is with him, when he gets a client, he charges them no matter what happens with the case. This is what you are paying me. Even if they go get a different lawyer, he still gets paid. Oh, you're not a lawyer. You could be a lawyer though. We're gonna talk Jasmine into becoming a lawyer. You could go to school with her.
There's the way the report is read, it just says they observe him traveling at a high rate of speed. Do you mind giving me a couple minutes to call the officer before we make a ruling on PC? Or do you just want to make a ruling now? Because the offense report is very lacking. They might have.
No, I'm just gonna rule now.
I
You guys can just go re-indict it,
Yes, Judge,
you
I
know.
understand.
Mr. Gus, I'm gonna find no probable cause in your case, but let me alert you to one thing. You know, every single day, multiple people die in Harris County because people drive in a boneheaded manner. You know, we're not asking for much. We just want our streets to be safe. You know, I'm gonna find no probable cause now. But keep our streets safe. We're not asking for much. You know, when you're doing things that you're not supposed to do, bad things are gonna happen. Your life is hard enough as it is. When you pick up felonies and misdemeanors, all you're doing is you're making your life even more difficult. What are you doing with yourself these days?
I do.
Yeah, what do you do?
I'm a welder in the plant.
You're a welder, so you make great money. You want to throw your life away because of some stupid, you know? Make better decisions, all right? All right, hang tight for me. Just take a seat back. All right.
Hubler, page 7.
Dude, that was your lucky day. Did Victoria just sneeze again? Guys, I'm worried about Victoria.
Now, if you were able to supplement it at a different time, and then that's with you guys, right? But
Thank you.
yeah, and understand, you'll never hurt my feelings, right?
Yes, Judge.
Like, so. All right, good morning, Mr. Hubler. So this is Mr. Butler's client, right?
No.
I just have.
I know which one.
Who? That's it, yes, okay, can we do that next? Is he here? Okay.
You checked in. Yeah,
Mr. Butler, we'll do yours next, okay?
Okay, Judge, thank you.
How many times has this dude taken off on us? Mr. Hubler, I'm sending you for a drug test right now.
I checked myself into an,
Stop. I'm sending you for a drug test now. You must come back. If you fail to come back or if you fail to take the test, I'm gonna make your bond so high you're gonna have hair falling out. Do you understand? Take a seat, don't leave.
Next is page 20, Yepez, come on up.
Yeah, and then we'll do Spanish, yeah. Luis, let me just do this because I got the, Good morning, Mr. Yepez.
Morning, Your Honor.
Sir, you're charged with driving while intoxicated, second offense. You're facing up to a year in jail and or a $4,000 fine. We're going.
I'm sorry, the judge got the wrong guy on this one, guys. I hate to say it. Because look at his hair. That is absolutely not a bowl cut.
To do probable cause, you have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Sure.
Okay.
On October 12th of 2024, officers conducted a traffic stop on the defendant's motor vehicle after observing it drive without lights when required at night on a public roadway. Officers also observed the vehicle displaying heavy front side window tint. Upon contact, officers noticed the defendant with signs of intoxication, namely very slurred speech, glossy eyes, strong odor of alcohol in the breath, and very poor balance. SFSTs were conducted 6 out of 6 on the horizontal gaze and stagnus, 8 out of 8 on the walk and turn, and 3 out of 4 on the one leg stand. The defendant did admit to drinking. DIC was read, but the defendant refused. Officers obtained a blood warrant and that was signed. The defendant's previous DWI is from 2022 in Indian River County in Florida County, where he obtained a conviction on that.
Okay, just one prior DWI?
I do see just one, Judge.
Okay.
And Your Honor, if I may jump in, This is the one that you found PC on yesterday.
Correct.
And so I want to tell you that my client has already jumped on the interlock device. He has an appointment tomorrow, Mr. Yepes.
It's Monday morning.
Monday morning.
Yes, sir.
So he's already on top of his game, Judge, on that. I did see that it's kind of weird, like he's got a bond that was set, but then like the case was dismissed for no PC before he ever had an opportunity to make a bond. So we're asking the court to grant him a pretrial bond.
On bond? Has he made bond in the case?
No, Judge, it was for release part of those.
We do have a surety standing by, but under these circumstances, and of course he flew here from Florida, so he's hired an attorney, he's taking care of his business. He does plan on
What's your position?
Judge, just given the recency of the previous DWI, state would be opposed to a PR bond and the
oh, come on.
defendant's cases.
When was
Come
the
on.
other DWI?
2022, Judge.
That has nothing to do with his ability to appear in court.
There's also safety of the community, Butler, you know that.
Of course I know that.
So, Mr. Yepes, I'm going to find that there's probable cause to go forward with the case. Do you have a valid Texas driver license?
I have a valid Florida driver's license.
Do you have liability insurance in
Sure.
your name?
Sure.
Okay. You're not allowed to drive unless you have both. I am ordering you now, and I'm putting a restriction on your license that you're not allowed to drive any vehicle that doesn't have an ignition interlock.
Sure, Your Honor.
If you're caught driving a vehicle that doesn't have an interlock on it, you will go to jail and your bond will go away.
Yes, Your Honor.
Make it high.
Yes, Your Honor.
Understand?
Yes, Your Honor.
I'm also ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication.
Yes, Your Honor.
I find that you're consuming alcohol, and I don't care where it is, where it's from, what it is. Likewise, I will put you in jail. You will not get any more PR bonds.
True.
Now, you live in Florida, correct?
Yes, Your Honor. Right. I have 3 children here in Houston. I have a business in Vero Beach where I was born and raised. So I commute back and forth. I'm here at least 2 weeks, a month, and have been since I was divorced.
So
7
you're
years ago.
here quite.
Yeah, I have 3 children that are all young. My daughter's a freshman at Memorial High School, so volleyball, I try to be as hands-on as I can be, but still be.
My only concern is that you will be randomly called upon to take a drug and alcohol test.
Sure.
If they call you and you're in Florida, you will have to go to a Quest Diagnostics. If you're in Florida,
Yes, sir.
don't go to a Punka City lab. You have to go to a
Quest
Quest. That's a legitimate lab that we know does legitimate work. So it has to be a Quest. Get the result to Mr. Butler. Mr. Butler will get it to us so we know. If you fail to, if they call you and you don't take a drug test or you don't take the alcohol, whatever it may be, I will revoke your bond.
Yes, Your Honor.
Okay, I will give you a PR bond now, but this is the only one I'm going to give you. I will not give you another one. If you
Sure.
violate conditions, you pick up a new case, drive when you're not supposed to, because it's very possible that you'll lose your license because of this. If you do, you may not drive.
Yes, Your Honor. I completely understand and I appreciate it.
Okay, now, I will, because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with Mr. Butler and
Absolutely.
he'll tell you if and when you have to come back to court.
Yes, Your Honor.
If Mr. Butler tells me that he can't get a hold of you, likewise, you know what happens.
I'm sure.
Yes,
We
Your Honor.
have great communication, Your Honor.
Yeah, I trust you, Mr. Butler. I know.
Thank you, sir.
Okay, so for now, I will have you go to Victoria Center Reset. You will eventually have to meet with pretrial for all the conditions, and after that, you'll be free to go.
Thank you, Your Honor.
So you already have the date, Mr. Butler, right?
Yes, Your Honor.
Okay, I think we're good then.
All right. Thank you so much.
Sure.
All right, thank you.
Have a
Thanks for coming.
wonderful Friday. Absolutely.
Too. Take care.
Thank you.
I didn't want him to get a PR bond. You want to know why? Because his attorney was mean to Michael. I didn't like that.
Last name,
Be professional.
counsel, in line, on the phone.
Nathan.
Go ahead.
It's Via Gomez.
Gomez, Via Gomez.
Via Gomez.
All right, go to page 18.
Okay. Oof. 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 2,823 days old.
That's accurate, Judge.
Mr. Villa Gomez, come up.
Don't come up as a trap. Stay back there where you're
So
safe.
before you leave, Nathaniel, we'll need you to do a motion to stop.
Aquí en el centro, por favor. Solo mire el juez, no me mire a mí, le contestan solo en español.
But I can do that. And Judge, we have this worked out with the state, just so you know.
Para que solo mire el juez, no, le dije que solo
Well, I
mire
don't know
la
because
cara
it's
del
our
juez.
probation.
Understood, Judge.
You know, all I know is that this case is older than, I mean, it's older than Jesus, man. You know? Tell me about your compelling story.
Okay, Judge, so my client was born in the 70s here in Houston. He is a United States citizen. His parents took him to Mexico. He was raised in Mexico until he was a teenager. He came back to Houston when he was about 18 or so. In any event, he got this DWI charge in 2016. He pled to probation. He didn't understand all that was required of him. He went in, I think his first setting, and told them, look, I can't do that. I can't afford the probation. What I'd like to do is turn in this portable device and turn myself in. They said, we'll let you know. So I have gotten with your CLO, and she has confirmed that that was, I have the printout if you'd like to see.
Victoria, what you got?
Yes.
Nathaniel, I'll take a look.
Went to meet with his probation officer the first visit. They were reviewing fees with the alcohol monitoring device. He said just that reported they didn't want to participate. The next they told him that they have to staff the case with the court. It was like the case was submitted, and they requested an MRP, and there was no contact with the client.
And so
Just decided he didn't want to do it and he left.
Well, so, and Your Honor, my understanding is he went in to turn in the device. He had every intention of turning himself in at that point.
But he didn't.
Well, they wouldn't take him because the MRP hadn't been done. Understood.
They tell you to come to court, you took off, and now 6 years later, you come back and you want mercy?
I think that he had every intention of coming and being square with the court. It's just a matter of timing. The MRP wasn't drafted at the time. But I would say this, Judge. So in the ensuing 8 years, because I guess it's been 2016, 2024. In the ensuing 8 years, I have tax returns for all of those years. He has children ranging from 1 to 22 of the same wife. All of whom are well provided for. During that time, he has used his passport to travel to Mexico several times. He's never had any issues with Border Patrol. I have pictures of him attending his father's funeral earlier this year with a headstone with a 2024 date of death, with him in front of the Oferta. He has done all of those things. He wasn't on the lam by any stretch.
Of course he is. What do you mean he's not on the lam? He's on the lam. There's a warrant for his arrest. I have no idea why no one would arrest him. I don't know, but it's now time. I mean, it's now time to pay the piper.
And so, Judge, it's showing we have a deal worked out with the state if the court is agreeable to it.
What is the deal?
So I can talk to you about the deal, Judge. So I looked at the probation. It looks like what I'm mostly concerned about is the defendant promised to pay restitution.
Oh, there's restitution on
Yes,
top of it.
Judge.
Oh,
Yes, Judge.
oh.
I indicated that if the court would bless the offer, I would offer a time served if he paid the restitution bill today.
No, he doesn't pay restitution. He's looking at he's looking at a year in jail. That's what's going on. If you don't pay restitution, you're looking at an entire year in jail. That's what's gonna happen. But you've been gone for 8 years and you want me to time serve this case? How much is restitution?
$546.
And his daughters are going to get the cashier's check pursuant to that.
And we made contact with the complainant. She confirmed she never got paid. She still wants payment. So we drafted a
Of course,
bill.
I would want payment too, but
Address.
I can't possibly do.
I can't emphasize enough, Judge, how at his first meeting, he said, I can't afford probation. It was his expectation that he'd be taken in now. So although my client is a citizen, the cultural understanding of you need to go wait for the formal MRP rather than him just showing himself up. So in the ensuing time, his He has avoided trouble. This is his one and only time having been arrested. He has taken care of his children.
I'm not
whose
going to
age-
reward him for doing things that he should be doing anyways. If you have children, you have to take care of your children. If you have a wife, you have to take care of your wife. I'm not going to reward you for doing things you should be doing anyways. You are charged with a DWI. You're facing a year in jail. You take off for 8 years, and you want me to just a slap on the wrist? Life doesn't work like that. In life, there are consequences. And the consequence is when you fail to do what you're supposed to do, you're looking at potential jail time. And in your case, you're looking at an entire year in jail. And it really would not be fair for me to just give you the proverbial slap on the wrist when you're gone for all this time, when everybody else does what they're supposed to do. And when they're here, they get time served, for doing what they're supposed to do. He's been gone for nearly a decade. I can't bless a time served, Nathaniel. As much as I love you and appreciate your tenacity, absolutely not. It's not fair. And if he doesn't pay restitution, then he's going to be doing a substantial amount of time in jail. That's it.
And so I would just reiterate, Judge, that he came in, it's not a traditional absconder case. He came in and said, I cannot afford this. And then
it's not a years.
Well, he assumed, he showed up with the intention of turning himself in. So
But he didn't.
his understanding of what happened, is inaccurate, right? It has to be staffed with the court and MRPS
No,
issues.
I want you to understand something. I'm not out, we're not out for blood, right? I'm not going to hit him with 6 months or anything like that. But he needs to understand that there's a consequence, right? And I think it's only fair, and that hopefully with the consequence, he'll understand that we mean business and you can't just take off for 8 years, not expect something.
So what kind of an offer would you be?
30 days.
30 days with restitution.
If restitution is paid. If no restitution is paid, 365 days. I hope you understand, we mean business, Mr. Villagobis. It's unacceptable that you take off for 8 years and expect us to just turn belly up. Life doesn't work like that. And I'm not going to reward you for doing things that you should be doing anyways, which is being a good father. You should be doing that anyway. Now, you can appreciate and understand that we mean business. So, I guess what we'll do is we can set up a hearing if you want. He can, if he wants to take it, and I'll certainly give him time to turn in.
So
No.
Judge, if we can a reset so that I can, I was hired on this case yesterday.
Absolutely, I'm more than happy to give you time, of course, but I can't, it's not fair, Nathan, it's not, it really is. So, Shatoria, get ready for your hearing, please, just in case, and I can't imagine that the same probation officers is still there. So just get all the records you can and we'll go from there. And, I'll give you 3 weeks. If you want 3 weeks, we can come back and he either accepts it or we'll have a hearing. Yeah. Sorry, Nathaniel. All right. Oh, wait a second.
Un momento.
I'm now going to put a GPS monitor on you, so I know that you're not going to take off. And on your other ankle, I'm going to put another monitor to make sure you're not drinking. While you're on this probation, you're not to consume alcohol or illegal drugs. Do you have a Texas driver license?
He does not.
Tina P, thank you so much. I appreciate it.
No, then you will also sign an affidavit with me today promising me you're not going to drive. If I find that you drive, I will have a contempt hearing. You'll be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yo, señor. Tiene que hablar. Sí, señor. No, señor. Yes.
I know that you're upset, but I don't think it's unreasonable what I'm doing, Nathaniel. I know that you want to fight to the best for your client,
Hey,
but
you're a member.
I don't think it's unreasonable, that, at the end of the day, with all the credit, with all the time, and the 3-for-1, it's. Can you waive the fee for me, please, for the devices, guys?
No phones. You see that, Bill?
Hey, Jim.
I'm gonna have you come up here and swear to me that you're not gonna drive. After that, we will have you sign a reset with Victoria. After that, you'll get with pretrial for your bond conditions. Don't, if you take off on me again, so help me, I'm gonna make your bond so high. Don't take off. You must come back and you must not consume alcohol. Do you understand me?
Entendió, señor. Sí. Yes. A la izquierda. Allá.
All right, Judge, the next one is page 1, Bolivar. Gabby.
What page you say?
Page 1, top of page 1.
My name is Bolivar. Do you speak English?
No. Hola, ¿qué tal? Soy Luis, el intérprete, mucho gusto.
Bolivar, you're charged with theft, facing up to 6 months jail and or a $2,000 fine. I'm going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Officers were dispatched to a Walmart in Harris County, Texas, in response to a theft.
Do not say Steven, she goes with you because she's about to pop.
The loss prevention officer reportee informed officers she
She is
observed the
pregnant, right?
defendant
We all
skip
agree?
scanning and passing points of sale without attempting to pay. When the defendant was stopped by an employee to examine the receipt, the employee discovered merchandise not on the receipt, concealed inside of a large plastic bin. The items included men's, women's, and children's clothing.
Maybe she's not pregnant, but she's pretending, and inside that pouch she stole Victoria's lunch.
Tried to get them out for you.
That's what I was wondering, the value.
So low. Look how low she is.
$640.95.
That's a lot. Ms. Bolivar, I'm going to find that there's probable cause to go forward with the case. Tell me, are you United States citizen?
Mire el juez. ¿Usted es ciudadana americana?
No.
No.
In this country.
¿Está en este país con permiso o sin permiso?
Con permiso de migración.
¿Con permiso de qué?
De migración.
With immigration's permission.
I don't know if you are or not.
No sé si los
Quite frankly, it doesn't matter to me, but I am going to impart to you that if you're not in this country with permission and you go to jail, immigration will find you. They will put a detainer on you. You will sit in custody until this case is over with and then shipped off to immigration and wait another 6 to 9 months in immigration to do whatever they're going to do. So I would be very careful. I am ordering you now as a condition of your bond not to go to any Walmart for any reason. You said Walmart, right?
Walmart.
You understand?
Entendió, señorita?
Yeah.
Yes.
This is a bond conditions. If I find that you go to Walmart, or if you pick up any more criminal cases, I will revoke your bond, put you in jail. You will not get any more PR bonds.
Okay.
What do you do for a living, ma'am?
¿Qué se dedica usted, señora?
No trabajo porque estoy embarazada.
I'm not working because I am pregnant.
Are you married?
¿Eres casada?
No.
I nailed it. Yep.
How do you
I knew
survive?
it.
How do you eat?
Sobrevive, ¿cómo come?
Estoy con, no sé, tengo pareja, pero no estoy casada.
Okay, well, I'm with my partner, but I'm not married to him.
Okay, so do you live with your partner?
¿Vive con su pareja entonces?
Sí,
Yes.
Works?
¿Su pareja trabaja?
sí.
Yes.
What does your partner do?
¿A qué se dedica su pareja? ¿Qué trabaja?
Barbera.
He's a barber.
How much money does he make a
¿Qué
month?
tanto dinero gana él por mes?
2,000.
Hold on. No, guys, we have to figure this out. So bowl cuts cost $2 each at least, right? He's a barber. Bowl cuts cost at least $2 each. He can do what? 8 a day, so that he makes $16 a day. That's how much. That's how much he makes, Judge.
1,000.
Do you have any other income from any other sources?
¿Alguna otra fuente?
No.
No.
Did you want to apply for an
¿Es
appointed
solicitar un abogado de
lawyer?
oficio para que le ayude?
Por favor.
Please.
I'll have you fill out an application. I'll have to take a look whether you qualify. Are you wearing a Rolex watch?
¿Tiene un reloj Rolex, señorita?
No.
No.
Is that a Rolex?
Is it a Rolex?
No.
No.
I'll have you fill out an application. I'll
Adelante.
take a look to see whether you qualify or not. Be that as it may, don't go to any Walmart.
No vaya a ningún
This is
Walmart.
the only warning you will get from me. Do you understand? Okay. Don't leave until you sign our bond conditions as well.
I
Can you
trust
follow me going to
Judge
Walmart?
I do.
Yes.
Going to any Walmart? Man, that looked like a diamond encrusted Rolex, you know? Like, come on.
It looks like a day justice.
Man, we've had people here with Gucci decked out and they want an appointed lawyer, you know? Come on. Gucci, Gucci, goo.
Yes.
Who is it? Yeah. Owen? All right, page 12, Judge Owen,
Okay.
come on up.
Good morning, sir.
Morning, Judge.
Matthew Owen,
It's scary.
charged with driving while
It's very scary when the men folk start thinking alike, guys.
intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. Bless you. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
On October 19th of 2024, officers patrolling the 1100 block of West Main Street conducted a traffic stop on the defendant's motor vehicle after observing it signal a right turn, but turn left, making a wide left turn into the wrong lane. Upon making contact with the defendant, they observed he was the driver and sole occupant of the motor vehicle and observed signs of intoxication, namely moderate odor of alcohol in the breath, red bloodshot eyes, and slurred speech. SFSTs were conducted, 6 out of 6 on the horizontal gaze nystagmus, 7 out of 8 on the walk and turn, and 2 out of 4 on the one-leg stand. The DIC was read, the defendant consented to breath, and the breath results were 0.114, 0.109. And this defendant has no criminal history with an eligible driver's license.
Mr. Owen, I'm going to find that there's probable cause to go forward with the case. Do you have valid liability insurance in your name?
Yes, sir.
As long as you have both, you can continue to drive, but I am ordering you not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming alcohol, I'm going to put you in jail. You will not get more PR bonds. Do you understand? You have a lawyer. Good job on having a lawyer. Because you do, I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with him and he'll tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. Do you understand? For now, we'll have you go to Victoria, sign a reset. After that, we'll get you with pre-trial for your bond conditions, and after that, you're free to go. All right?
Thank you, Judge.
Please. Yeah.
Johnson, Eric, page 8.
Eric Johnson. Mr. Johnson, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine.
Eric Johnson is the name of that other bow tie judge. You know, who thinks a lot, who's nice and slow, deliberate.
Going to do probable cause, you have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, sir. Okay.
Officers were dispatched to a minor crash in Harris County, Texas. The complainant advised she was driving west when she observed the defendant driving in the opposing lane of traffic down the road. The complainant swerved to avoid the defendant, but her car was still struck by him.
So she's oncoming?
Yes, Judge. She followed the defendant down the side of the road until his car hit a median and it stopped. Officers arrived on scene. The defendant was asleep behind the wheel with the engine running and keys in the ignition. The defendant did admit to drinking at a bar. The defendant was detained, and when officers attempted to remove the cuffs, the defendant fell backwards into the officer's arms. Officers then observed signs of intoxication, namely odor of alcohol in the breath and bloodshot eyes. SFSTs were conducted, 6 out of 6 on the horizontal gaze and nystagmus, 5 out of 8 on the walk and turn, and 2 out of 4 on the one-leg stand. The DIC was read and the defendant consented to breath. The breath results were 0.120, 0.117. And this defendant has no criminal history. His license is currently suspended.
Find that there's probable cause to go forward with the case. You have a Texas driver license. Not allowed to drive, and making that a condition of your bond. You will be signing an affidavit with me today promising you're not going to drive. I don't care what's going on in your life. You know, that's how most collisions and deaths occur head on oncoming traffic. You're lucky. So, I mean, they're charging people with murder now when people die as a result of this. Do you understand? Get the hint. No more alcohol, no more dope. And I'm going to test you. If I find that you're consuming anything, any alcohol, any illegal drugs, I'm going to put you in jail. If you have a problem, you better address it, because if you don't, I'm going to do it for you, Mr. Johnson. It's the only warning that you will get. Do you understand? This is an affidavit that you're signing with me today. I don't care what your reason is. You cannot justify getting in the car for any reason. Do you understand? How old are you, Mr. Johnson?
Sure.
What do you do for a living? Speak louder.
At Little Caesars and make videos.
Okay. What do you do at Little Caesars?
I just became the manager.
Great. Good job. Just do a good job. Put your heart into it. Who knows? Before soon you may own a store. How much money do you make a month, sir?
A month. About 1,100.
Who do you live with?
My mother. My mother.
Okay. Did you want to apply for an appointed lawyer, sir?
Yes.
Oh, come up. Are you your mom?
Yes.
Come on up, Mom. Thank you so much for coming. Did you hear?
Oh my God, I did. I didn't know.
Just keep an eye, please. I don't want to have to keep an eye on him for you.
He's a good kid. He doesn't get in trouble. He doesn't do anything.
Let's not talk, I don't want to talk about the case, right? But just, you know, in life, sometimes you hit a brick wall. It's not the end of the world, but hopefully it's enough of a wake-up call to get you to understand that you're lucky, number one, to be alive. You're lucky to be here standing with us now. And you're lucky even more so to be not charged with something even greater upstairs, right? Count your lucky stars, because it could have gone a lot worse. You have a mom, she cares for you. Just take care of it. Okay. I'll have you fill out an application for an appointed lawyer today. We'll have you talk to someone. I've ordered him no alcohol, no drugs, no driving until you get a license and liability insurance. If you can get a license and liability insurance, it doesn't matter. If you don't have a license, do you think, even if he gets into an accident, if he doesn't have a license, do you think the insurance company is going to cover you? No, no, you don't have a license. You're not supposed to be driving.
Give him insurance then.
No, but insurance companies are in the business of denying claims. They don't like to give out money, and they're going to use any excuse that they can find to not pay out, because that's the business that they're in. If you don't have a license, they're going to say, well, you're not supposed to be driving anyways. We're not going to pay it out. I don't know why they would take it.
They charge him $3-something a month. I mean, they
I
knew
don't
he
know.
didn't have a license.
But look, don't drive until you get a license. It is your.
I am officially sure Victoria is very ill, extremely ill. Where is Michael? I need to know how Victoria is. Fozzie, call Michael. It's 6 o'clock in the morning. He'll be awake, I'm sure, maybe. I don't know.
Responsibility. Do you understand? Okay, I'll have you come up here, swear to us that you're not going to get a license. They're going to give you an application. Hold on. I need you to sign a reset with Victoria. After that, you'll get pre-trial for your bond conditions, and then we'll have you wait in the jury box. Okay? Thank you for coming, Mom.
Longoria. Page 8.
Hello.
Crystal Longoria. Miss Longoria, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you. Okay.
This is really bad timing, Judge. My internet's not working.
Sure.
Just when I get up here.
I hate you. It hurts.
Do you see a prior GOB as well, or just one PR bond on Longoria?
PR bonds.
So this is, but this is the second one now.
Crystal.
Yes.
So we're undergoing a prosecution investigation. While speaking with the defendant, officers found the defendant had a misdemeanor. Sorry, Judge.
My son will never be a grown man.
On March 25th of 2024 in Harris County, Texas, officers were dispatched to a disturbance. Officers met with the CW. CW and the defendant were in a dating relationship but are broken up. The defendant came to the CW. CW said no. They got into a verbal argument. The defendant slapped CW and punched her, causing pain.
So she slapped and punched?
Yes.
Where?
I can look at the dims. It says the defendant slapped her with an open and closed fist and then fled the scene. The CW said that they felt pain and discomfort, but it doesn't say where the slap happened. I'm pulling up the offense report, Judge,
Yeah.
to see if
Okay.
that says more. Okay. On the left side of her face.
You know whether this complaining witness wants to continue to have contact with her?
I'm looking at the notes, Judge.
Okay, Ms. Longoria, I'm going to find that there's probable cause to go forward with you.
I too feel like I don't really have a lot of words today. I'm struggling. Someone else is going to have to pick up the load, Kelly.
The case, there's a protective order that has been issued in this case. I will get to know it because if you violate this protective order, the state can and will file additional charges against you. Things will go sideways real quick. So at this point, I'm going to order you not to have contact until I know that he wants to have contact with you. I'm also ordering you not to be in possession of weapons as well.
Yes, sir.
If you violate these orders, I'm going to put you in jail. You will not get any more PR bonds. This is your second PR bond because you've taken flight on us one time before. Again, no more. Do you understand?
Understand.
How old are you, ma'am?
I'm sorry, I can't hear from this ear.
How old are you?
I'm 29.
What do you do for a living?
Right now, I just do makeup on the side. I just had a baby, so I don't do anything.
Judge, the defendant does have a conviction for bail jumping in 2022. And in regards to the last question that you asked, we have not been able to successfully make contact with the complaining witness, so I don't.
Where's the bail? Because I don't even, is that must be out of county because I don't see it.
It's in Cameron County, Judge, and she did TDC time on that. She did 2 years TDC on felony bail jumping.
Any other prior assaults against this person that you see?
No, Judge, not in Harris County at least.
One more question. Any alcohol or dope as an allegation?
Let me check.
How much money do you make a month, man?
I make at least 600.
600?
Yes.
Okay. Did you?
I do have something I can say. I am struggling right now with the drug problem, with the drug addiction.
So I'm ordering you not to consume alcohol or illegal drugs.
That's right.
And when we test you, if I find that you're using, I'm going to put you in jail and I will put you in a rehab facility.
I understand.
Don't use. Do you understand?
Completely.
And the offense report doesn't mention.
Guys, Nan lives in Nashville, Tennessee. She's neighbors with Fletcher. Right? Fletcher. Yeah, he's in Nashville.
And alcohol or drugs specifically.
I'm gonna
Yeah.
work it regardless now.
And I'm sorry, Judge, I was reading the DIMS at first for another case and then I switched over, so.
Okay.
Yeah.
I will provide you a lawyer today, ma'am. Understand, under no circumstance. Nope, at all. Do you understand? You need to also understand one thing, ma'am, is that you have a pen trip. Anytime you are charged with a serious felony offense, they can use that pen trip to make you a 15 to life case. When you have 2 pen trips, you're labeled as a true habitual. And in that instance, it's a minimum of 25 to life when you're charged with a serious felony. So when you're out there in the free world, you got to behave yourself, because if not, you could be on the upwards of, at a minimum, 15 years. Do you understand? So guys, no alcohol, no drugs, random urinalysis, no weapons, no contact for now, okay? All right, let me see if I have an application. I have an application already, so we don't need you to fill one out. I'm just gonna have you sign a reset. I'll have you meet with pretrial. They're gonna have you sign for your bond conditions, and then we'll have you take a seat while we wait for a lawyer for you.
Thank you.
Okay.
Martin? Page 9.
Don't you argue with Victoria. She'll tell you what your name is.
Is it Martin?
Martain, Martain, sir.
Mr. Martin, you're charged with evading arrest or detention. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On 9/19/2024, an officer in full uniform driving a fully marked vehicle observed multiple people loitering in front of Siesta Mart in Harris County, Texas. Officer parked in front of the store and the defendant began to quickly walk to the south of the building. Officer told the defendant to stop, but the defendant began to run when he got to the corner. Defendant ran to an apartment complex and the officer lost sight.
That's it?
No, Judge. The officers established perimeter, K9.
But even What's he doing wrong?
It just says he was
Standing
loitering.
flat.
It just says he was loitering, Judge. I'm trying to see if
So-
there's more
No,
detail.
I don't think so. I'm gonna find a probable cause.
Okay, Judge.
Dude, be careful, man. You know, life's hard enough as it is.
Judge, I just got out of prison from that block. I understand how it works.
You know, all right, just hang tight for me, will you?
Yes, sir. Thank you.
Munoz? Page 10. Bolivar? Munoz, Camara?
Miguel Munoz.
Yes.
Munoz, you're charged with unlawful carrying of a weapon in a prohibited place. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you, sir. Please have a seat, sir. Okay.
An officer was working an off-duty job at a bar in Harris County, Texas, when he observed the defendant walking to the bathroom. The defendant dropped a handgun from his waistband directly in front of the officers. The defendant immediately picked up the gun and attempted to walk away from officers. Defendant was aware that he was not permitted to bring the gun inside due to signs posted in both English and Spanish at the entrance of the business.
You're on bond for a felony assault and now you have a weapon?
I was just placed on bond.
Stop, don't talk about the case. All I'm gonna tell you is that I gotta imagine one of the bond conditions on your felony case is for you not to have a weapon. I'm gonna find that there's probable cause to go forward with the case, Mr. Munoz. I'm now going to have you sign an affidavit with me today promising me that you're not gonna have any weapons. If I find that you have a weapon, I will have a contempt hearing. You'll be facing an additional 6 months every time you have a weapon. Do you understand?
Yes, sir.
I'm also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you consume any kind of alcohol or drugs, likewise, I will put you in jail. You will not get any more PR bonds. Do you understand?
Sir.
An ace.
Bless you.
Oh, wait, no, Victoria's not on that
Mr.
side.
Munoz, what do you do for a living?
Okay.
I'm a handyman.
I'm 100% sure I heard Victoria cough at the beginning. But now that I keep hearing these sneezes, I think it's someone else sneezing. I think she was the cough, and now someone else is sneezing. Someone else in there is very sick.
I work on cars and houses. I just had an injury about on the 6th of this month, October.
What happened?
I was remodeling a house because I had just had a kid, and I was remodeling the house, and I tripped and landed on my hand.
Okay. Are you still able?
No, actually, the officers at that time, when they arrested me, I told them that I had a hurt arm, and they refractured it.
No, I'm sorry to hear about that. You want to apply for an appointed lawyer?
I was trying to see if I could get some time to come up with some money to pay for a lawyer.
Sure, of course. Yeah. If you want, if you have any issues, come back and then we can talk about it.
Yes, sir.
I'll give you 30 days and then you can see about hiring counsel. But what I would do is I would do it really quick because you're on bond for a felony case and it's very possible that when they get wind of this, they revoke that bond upstairs. So don't sit and wait. It's something that you need to get on quick. I'm going to have you come up here, sign an affidavit, say promising us you're not to have any weapons. I'll have you sign a reset with Victoria. Then I'm going to have you get with them. No dope, no alcohol. Do you understand? All right. And then after that, we'll let you go. And when you come back, please have a lawyer. Okay. All right. That way.
I have no idea what that is, but yeah, I'll try that, please.
Mr. Petronia, come on in.
See whether you're amenable. My guy has two days credit. He requires another 8 to make 30 days. So if you're amenable to weekend reporting, it would enable.
There's no weekend reporting, is
As far
there?
as I understand, there's still no weekend reporting at all at the
Let me
moment.
look in, let me reach out to administration to see if there is. I don't think that there is because they don't have the manpower.
Because the problem my client faces is that he will lose his job if he were to do a consecutive 8 days. Friday to Sunday would enable him to keep his job because he works Monday to Friday.
Let me reach out and see if it's possible. If it is, I'll acquiesce to you, but I don't know for sure. Let me finish the arraignments and then we can talk. You can always zoom in and I'll ask for you. And I'll let you know, okay? So give me a bit because I want to get through all this and then as soon as I'm done with the arraignments, I'll reach out to administration, see if we can, okay?
Page 12, Perez.
But Nathan, of course, I'd like to help you so he doesn't lose a job. I just don't know if it's possible. If it is, I'll acquiesce to you.
Understood, Judge.
Yeah, okay. Joe Perez.
Sir, Your Honor.
Mr. Perez, you're charged with criminal mischief. You're facing up to 6 months in jail and or up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On August 23rd of 2024, officers were dispatched to a Chevron gas station in Harris County, Texas, in reference to criminal mischief. Officers made contact with the complaining witness, who stated that the defendant was at pump 2 and complained that his card was not working. The complaining witness stated he went outside with the defendant and saw that 25 cents had been pumped, then the transaction was canceled. CW told the defendant that he would have to use the card again to start another transaction. The defendant became irritated and the complaining witness made his way back into the store. The defendant followed him into the store, asked for $30 on pump 2, went out to his motor vehicle and began to pump gas. The defendant entered the motor vehicle with the pump still attached. $30 had been completed on the pump, then the defendant left without attempting to remove the pump, causing the pump and the hose to be separated from the in-ground meter. There were $500 in damages.
Did he mean to do it or was it an accident? Because remember, this is a specific intent crime. You didn't tell me anything that he's like upset to where he intentionally took off with the device.
I understand, Judge.
You know?
I'm just reading based on what the offense report said. It says the complaining witness did not see him even attempt to remove the pump.
I know, but people forget, you know, you're busy, you get this, like, you know, accidents happen, right? But if you're telling me that he's like flipping it off, giving him the bird, yelling at him, and then he just, but I don't see the intent.
I pulled up the offense report.
There's no rush, take your time. And if you want, we can come back and do this a little bit later so we can do everything else and then give you more time. You want to do that?
I'm looking through it, Judge, and I don't see that. We can come back to it.
Okay, sir, I'm just gonna have you take a seat. I'm gonna do a deeper dive in your case, just to see if there is probable cause. If you just don't mind, please take a seat in the jury box and we'll come back. No, don't. You have the right to remain silent. Exercise the right, please.
Randall, page 14.
This one?
No, that, I put a sticky note up there on top of the plan.
Okay, let me.
Randall.
Hey.
Page 14.
Are you Carson Randall?
Yes, sir.
Mr. Randall, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On October 19, 2024, officers arrived to the scene of a minor accident, 18311 block of Fensby Road. Officer observed the defendant, who was the sole occupant of the motor vehicle, exit the vehicle that crashed into a pond. Upon contact with the defendant, officers detected an odor of alcoholic beverage and bloodshot eyes on the defendant's person. The defendant admitted to drinking and operating the vehicle on a public roadway. SFSTs were refused, DICs were read and refused, and a search warrant was signed and executed. The defendant has no prior criminal history. He has an eligible driver's license, and he is 17 years old.
Are you here with anyone today, Mr. Randall?
Yes, sir, my mother.
Come up, Mom.
Just confused.
Don't stop.
Yes.
Don't say anything. Good morning, Mom. Did you hear what happened?
Sorry, I couldn't hear.
Did you hear what happened? No. Would you like to hear? Okay, can you read it again? But a little bit louder so she can hear.
Yes, of course. On October 19th of 2024, officers arrived to the scene of a minor accident in the 18311 block of Fensky Road. Officer observed the defendant, who was the sole occupant of the motor vehicle, exit the vehicle that had crashed into a pond. Upon contact with the defendant, officers detected an odor of alcoholic beverage and bloodshot eyes on the defendant's person. The defendant admitted to drinking and operating the vehicle on public roadway. SFSTs were refused, DICs were read and refused, and a search warrant was signed and executed. He doesn't have any prior criminal history. He does have an eligible driver's license, and he is 17 years old.
You said they did do field sobriety tests, or
No, they were refused, Judge.
everything was refused?
Everything was refused, yes.
Okay, so Mr. Randall, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you.
Yes, sir.
If I find that you're consuming alcohol or any kind of illegal drugs, I will put you in jail. You will not get any more PR bonds. Mr. Runcie, coming up. This is your client, Mr. Randall. Good timing. So I have just found probable
had a
cause.
nickel.
Essentially, accident, gets out, odor of alcohol, other indicia of intoxication, refuses all tests. Did you say they did get a blood warrant, right?
Judge.
So they've taken blood, don't know the results. It takes time to get the results of the blood. Regardless, I'm ordering you, like I said, not to consume alcohol or illegal drugs. I will randomly test you. If I find that you're consuming, I will put you in jail. You will not get any more PR bonds.
Yes, sir.
Do you have a Texas driver license?
Yes, sir.
Do you have liability insurance in your name?
Yes, sir.
You're allowed to drive if you have both of those things. If your license gets suspended, you may not drive.
Yes, sir.
Any prior DWIs or any prior alcohol contacts? Okay. Questions, Mom? Just keep a watchful eye. No more going to parties. If I find that you're going out and going to parties because you're 17, think you're invincible, not anymore.
Yes, sir.
You understand? What you do now will impact you for the next 40 years of your life. And the more convictions you get, the only thing you do is make life more difficult. It's already hard as it is. And when you start racking up convictions, no one wants these kind of people working for them.
Yes, sir.
You understand?
Yes, sir.
So make the most of it because you only get one chance. This is the only warning that you will get from us. All right. So for now, we'll have you sign a reset with Victoria. I'll have you get with pre-trial for your bond conditions. And after that, you guys are free to go. Oh, you have a lawyer. I will waive your appearance. You don't have to waste your time coming to court, but you must stay in touch with counsel and he will tell you if and when you have to come back to work. If he tells me that you're playing games and you're not responding to phone calls, text messages, I will issue a warrant for your arrest. Don't pick up any new cases as well. All right. Okay, guys.
Thank you, Your Honor. I also have Robert Garza on docket today.
That way, guys. I have Mr. Freeze, come up in the jury box, please. We took care of your other guy earlier. What was the name?
Robert Garza.
Yeah, I just, same thing, just, we found PC, no alcohol, no drugs, random UAs, and that's it. So I think he may be, that's him right there in the box, yeah, okay. But I don't, have you signed conditions with? Okay, so he can go with you, but he's got to come back so we don't miss him to sign conditions.
Yes, sir.
Okay, all right.
Judge, which was the one that you found no PC on right before the?
There was quite a few that there was no
Right,
PC on.
Martain.
Right, I'm gonna find one more, guys. One more.
Writing that is forged within the meaning of paragraph A. So to execute
Is
that.
that a lawyer or?
Negotiation.
We'll find out.
Yes.
So Judge, the issue in this case is what the definition of forge means. So I'm just going to cite to you the penal code definition of forgery, which is section 3221. And for purposes of that section, to forge means to alter, make complete, or execute or authenticate any writing And subsection C says, the definition of forged is just to possess a writing that is forged within the meaning of paragraph A. So to execute that
negotiation of that
is forgery, Judge.
Sanchez, I'm going to find if there's probable cause to go forward with your case. What bank was this at? I guess what we'll do is no contact with the actual company in question and no contact with the complaining witnesses. If you can file that. Ms. Sanchez, I'm ordering you as a condition of your bond not to have any contact with either the company or any of the complaining witnesses in this case. If you violate these conditions, I'm going to put you in jail. You will not get any more PR bonds. So is there a co-defendant?
There were 2 co-defendants.
Can I have the cause numbers? Because maybe it gets moved.
So one of them,
2 co-defendants, Sanchez.
so their names, one of them is Jonathan Garcia, the other is Mason Chiovaro. Cause number on Garcia is, sorry, Judge, I'm having to scroll. He has some other pending felonies as well. Okay, it's 2414675.
Okay. Really? That's
And on Mason Chiovaro. Again, Judge, I'm sorry, I'm having to scroll down.
so it's a way early cause number. And it's in 3.
Courtroom 3? It's in courtroom 3?
He has several forgery ones. I'm trying to figure out which one is ours. I think it's,
Transferred anyway?
I think it's 1779119. He has several forgery, and that's what I'm trying to figure out. It might be with felony because he has other felonies.
Is Chiovaro? Is that the other one?
Mason Chiovaro, yes.
Yeah, they charged him with a felony forgery.
Yeah, I think they are, because it's also the file date's different too.
Okay. Yeah, I think it goes to 3. All right, ma'am, your case gets transferred to court 3.
I'm also in PJs from here down.
So we're going to start working on that now. And then we're going to create a transfer order, and then you're going to head on now to court 3. Okay, so just take a seat, but don't leave, ma'am.
I was trying to confirm that too.
All right, Judge, on page 12, did you want to revisit Perez?
No, not yet. Is that no more?
That's the criminal mischief. At the,
No, not yet. Any more arraignments? Was that
We
it?
have Spanish arraignment, but we incorporated. That's it for now, Judge.
Okay, I gotta, let me just go real quick.
All right, guys. It's time. It's time to go. I'll be working 2 hours. Donald, no. Oh my. So, guys, thank you so much for coming back out today. Courts aren't open today, but I'll find something for tomorrow, I'm sure. I'm sure something will land in my. I have this, but I don't know if you guys can. Hold on. I don't know if you guys can handle it. I think you guys might get bored.
I'm sorry, I can't hear you. He's muted you.
I apologize. Are you ready for the last one?
I sure am. Mr. Amerson.
Yes, sir. Hold on.
Thank you.
Hold on. I'm going to just show you what I mean. The judge is awesome in this one. The judge is so good in this one. Except, I mean, he does let him ramble on a little bit. He should stop it sooner because it's monotone. Hold on. You'll see what I mean. I'm just going to fast forward it.
This today.
Okay. All right.
So go ahead, and if you have any issues with it, please advise the court.
All right. Well, on October 31st of 2023, I filed a Freedom of Information request that I sent to the Attorney General Christopher Carr. I requested my first appearance transcript, two copies of my first appearance transcripts, and 2 copies of my probable cause transcripts in my case. I asked for these copies according to rule.
See how monotone he is? And so, yeah, I don't know if you guys can take it for 34 minutes or not. I don't know. I'm iffy on this one. It's really good, but I don't know. But you want a picture, a baby picture of Fozzie? I have one. I have a baby picture of Fozzie. Do you want? Okay. I have a lineup. We're going to have to pick which one is actually Fozzie, okay? From these baby pictures. Here we go. Which which one of these baby pictures do you think is Fozzie? Fozzie got scared for a second there, guys. I'm just telling you. Fozzie was sweating his seat. He's like, what do you mean she has a baby picture of me? No, she doesn't. I'm definitely going with the double head. That's just what I'm going with. Yeah, one holding a beer. What about the abnormal middle piece one? Everyone say number one, and me and Donald are like, no, no way, man. We're going with the abnormal middle piece one. Wait, which one did Mike go say? The one holding a beer. Yep. Yep. Oh, Fozzie, you were so young then, so innocent. The micro. Okay, guys. Whoa, stop. Thank you so much for coming out. Thank you, thank you, thank you. I hope you guys have a great, long, slow, easy Sunday. I hope today goes slow for you before you have to go back. It hasn't changed much. All right, my outro. I'm finding it. I'm finding it. Be good, okay? Behave. We'll see you tomorrow.
Got these lights that close digital dreams. Through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted, sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right, even when my world turns gray. With a giggle, she lights the way. Her eyes mirror sky so blue. In her jokes, there's a truth so true. With each stream, she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm, in a way there's no alarm. Streaming tales late into the night, her laughter feels just right, even when my world turns gray. With a giggle, she lights the way. Kathy's laugh cuts through the gloom, eyes blue like a summer's bloom. Her humor dark and twisted charm, in a way there's no alarm.